You have to be very, very careful, because if there is no time frame from when the company is expected to like release your projects after you submit it, you cannot hold it against them, because there is actually no time frame in the agreements on when you should. So they can really waste your time and say, okay, it's not good enough, go back and re-record, it's not good enough, it's not going to be good in the market. They can make so many excuses, and you find yourself stuck in an agreement where nothing is moving for you. Hello guys, good day. My name is Janet Odunyi. I'm an entertainment lawyer and music publisher based in Lagos State, Nigeria. You're welcome back to my mini educational series where I talk about everything entertainment law, music publishing, and the music business. If you're just joining me for the first time, please do well by liking, commenting, and subscribing to my YouTube so you can get all the latest news and gist on whatever you need to know about entertainment law, music business, especially in Nigeria. So last week I made a video concerning the types of recording deal that you can be presented to as an artist, or if you're a music executive, you're a lawyer, when you're trying to negotiate deals on behalf of your clients who is the artist, or even maybe a producer. So I talked about the different kinds of recording deal that can be presented to your clients and how to know which would be okay for your career at any stage of the career. So today I'm going to be talking about the important clauses that you might find in a recording contract, because it's very, very important for you. And also please note that this is not a valid legal advice, or a legal practitioner's advice. You still need an entertainment lawyer, a music lawyer, to carefully help you to negotiate any recording deal that is presented to you at any stage of your career. So please take notes. Please don't take my word for it. Please, you still need to consult a lawyer when the real thing is presented to you. So let's go to the main business of the day. So first things first, when you see a recording deal or agreement, the first clause that would appear on it after the parties, whereas and everything, the first clause that going to be seen there is the term of the agreement. And terms of the agreement usually depends on whether it's a distribution agreement, a production agreement, a 360 agreement, or a master's licensing agreement. It totally depends. But normally in a 360 agreement, the term is usually for 4 years. So it's going to be like a 2 years contract period with maybe option periods, with maybe 1 year option periods each. So it's going to be like a 2 years original or initial period where you guys will engage yourself, where the company and the artist will engage themselves. And it can be option periods where either party can say, okay, we want to continue a relationship, we want to continue this contract and everything. So the option period can be 1 year, 2 year, 3 year, depending on the agreement with both parties. So you need to take note. So in a 360 deal, it's usually 4 to 5 years. In a master licensing agreement, it's usually 2 years, maybe with options to renew. In a distribution agreement, it could be 2 years, 3 years, just depending on whatever is agreed with both parties. Another clause you need to understand is the territory. So normally in most recording agreements, the territory is usually worldwide, but then it varies. So you can decide to grant a company in Nigeria, you decide to sign with a company, a music company in Nigeria, a recording agreement, but it will only be restricted to Nigeria and Africa. While you can also sign another agreement with a company in the US or UK, and it could probably be UK and its other territories. So you need to take note of all this. Do you want to grant the music company in Nigeria worldwide rights, or just restricted to Nigeria or Africa? So that's another thing you also need to take note when you're negotiating a recording deal. And so the next one I'm going to be talking about is rights ownership. So basically in a recording deal, the masters is always the subject matter, because both parties, the music company and the artist, come together to maybe enter into a transaction as regards the copyright of the masters and everything. So it's always very important to negotiate who owns the masters. Is it the artist or is it the company and everything? So it has to be clearly stated that that we are going into an engagement. The artist is going to be releasing some projects, maybe an EP, an album, and the artist would retain ownership of the masters, or the music, the artist is going to transfer the ownership of the masters to the company, and the company becomes the owner of the masters. So all these things needs to be like put into the agreement and clearly stated between both parties, agreeing that who owns the masters in this record deal. So the next clause I'm going to be talking about is whether the rights in the masters is being transferred or is being licensed. For distribution deals, the rights in the masters usually licensed. I won't really say it's licensed. Will I say it's a license? Yes, it is a license, because you are telling the distribution company to, like, you are giving the distribution company a distribution license to distribute and publish your works to the public. So it's a license. So there's nothing like ownership in a distribution deal. But for master's licensing deal, a master's licensing deal is also a license, because you are giving the company the rights to deal and exploit your masters for a number of years. It's also a license. While for a 360 deal, most times is an assignment, because the music company, the record company is investing in you, is paying for studio time, is paying for recording expenses, is paying for marketing and PR strategies, and it's also paying for artist development. So most times they make the argument that since we are going to be spending so much energy and money on the artists, it's only fair for us to own the masters in they own the rights in the masters. So they require that the artist transfers the right to the masters to the record company. So it just really depends on the kind of agreement that is being signed between the music company and the artist. So the next one I'm going to go to is compensation. Yes, this is very important, because compensation does not really come from masters, but it also comes from other income that the artist makes and everything. So in a 360 deal where the record label is going to like be in control of all the aspects of the career of the artist, so you know that the compensation is not going to be just on masters royalty. It can be on publishing, it can be on merchandising, it can be on live, on endorsements and all those things, even on live shows as well. It can also be on live shows and even on management. That's all it is about 360 deals, the compensation clause in 360 deals. Then for distribution, you know that it's just like giving the music company, distribution company, the license, the permission to distribute your work. So you know that yes, it's going to be compensation on masters royalties. And then for masters licensing, well, I've actually seen a masters licensing agreement where the music company says they'll be getting a percentage from not just the masters royalties, but from live shows, from endorsements, from merchandising. In my humble opinion, I think that in a masters licensing, you're only dealing with the masters, so you don't have to like touch on any other income that the artist makes by the side, because the subject matter of the contract is just the masters and not just the artist's career on the whole. So please, as I said, get a music lawyer before you sign any agreement, because a good music lawyer will be able to see these lapses and advise you properly on what or what not the master's licensing agreement should be about. Then I'm going to go to controlled composition. So basically, controlled composition would usually applies in 360 deals where the music company says that they have some interest. I'm not saying they have a right, but they have some interest in the publishing of the masters of the EP or project or single that was released during the term of the agreement. So basically, in my opinion, they are not saying they are going to own the masters or you should license your publishing rights, but they are saying that they are going to be getting a percentage from the publishing royalties you are getting from only the projects you released during the term of the agreement with them. So please, once again, the usefulness of a music lawyer cannot be understated here, because a good music lawyer would also advise you properly that you are not meant to transfer your publishing rights or your composition rights to the music company. So in my humble opinion, in a 360 deal, I don't think that the artist should be expected to transfer their composition rights or the publishing rights to the masters or to the project or to the album that they released during the term of the 360 deal. So I feel like this is something that the artist should get like a proper publishing company to be in control of the controlled composition. The only thing is that the music company can be a co-publisher with the publishing company that the artist eventually agrees to sign with. So they can be getting a percentage from the controlled composition, and the percentage they will be getting has to be stated in the agreement. So that's basically what controlled compositions entail. So once again, get a very good music lawyer to explain these things to you and also to negotiate a good deal as regards your publishing right, because if the record label is getting your master's rights, If the record label is going to get your publishing rights, you are basically left with nothing. Control compositions for distribution deal. If you are seeing any distribution agreements where the distribution company said they will be dealing with your publishing or your composition, I think it's a very red flag, because a distribution company is concerned with your masters and isn't concerned with your composition. So I think it's something that you can discuss with the distribution, that you don't want them dealing with your composition rights. So like you have a publishing company and that's that. Masters licenses too, it really depends. They are not meant to like deal with your composition rights and everything, but they can always get a percentage from your publishing, especially if they give you an advance to release any project under the master's licensing agreement. So they are kind of justified to get a percentage from your publishing royalties. So please get a music lawyer and all, so they can advise you properly. Also, the next one is termination. So basically, like back in the days, like back when there was also like music law or music business back in the days. So the thing about termination clause is that the music company is allowed to terminate the agreement anytime. But here's the thing, the artist is not given that special right to terminate. But now everybody is now like in tune with their rights and everything. We are now doing what is fair and unfair and how to like be on the side of the artist. So now termination clauses also allows companies and artists to terminate the agreement anytime and everything. So please, you also have to take note. It's a very red flag. It's a very big red flag when in the termination clause the company is saying that you are not allowed to terminate at any time. It's a very red flag. So make sure you tell your lawyers to negotiate that you don't want that kind of clause and everything, even if it means that there's only a time frame in which you can terminate. So the next one is minimum and release commitment. This is a very, very, very important clause that has to be included in the agreement. So the minimum and release commitment just really states that the number of projects or the album or the EP you are supposed to release during the term of the agreement. So the company will tell you that, okay, we want you to produce 5 singles, we want you to produce 3 albums, we want you to do 1 EP and everything. That's the minimum commitment. And the release commitment is the time frame in which the company is required to release that project from the time when it is delivered to the company. So this you have to be very, very careful, because if there is no time frame from when the company is expected to like release your projects after you submit it, you cannot hold it against them, because there is actually no time frame in the agreement on when they should. So they can really waste your time and say, okay, it's not good enough, go back and re-record, it's not good enough, it's not going to be good in the market. They can make so many excuses and you find yourself stuck in an agreement where nothing is moving for you. They are not agreeing to release your project. So even if they're giving you a minimum commitment, you also have to set that, okay, that after delivery and everything is satisfied, okay, you, the music company, have to release my projects in 6 months, in 12 months after delivery, depending on what you want, because it's very important, because many music companies can use that to hold you down for a number of time, and you realize that you've been with a music company for years and there is no project released in your name. So once again, a music lawyer is very, very important. So the last but not the least, this is the auditing and accounting clause. This is a very, very important clause to you as an artist, because it has to do with your compensation, your income, and your income and everything. So basically, this is you saying that you want to have the right to be able to access the company's book at any time or any given time frame that has been stated in the agreement, that you want to check how your money was made, you want to check how your money was spent, you want to check whether truly you are given the percentage that was agreed upon in the agreement. So it always has to be stated. Any agreement that has to do with someone collecting money on your behalf or someone giving you an advance, a auditing and accounting clause has to be in that agreement, because it protects you a lot from being cheated from music companies. I know so many people are always talking about how music companies are exploitative, they cheat artists, they are this, they are that. You as a music company, you as a musical artist always has to be on top of your game. You have to be smart. You have to work smart and not work hard. Let that clause be in the agreement that at any time that is stated in the agreement, you are allowed to get into to request for an audit of all the monies that were collected on your behalf by that music company. So that will protect you a lot and make sure that you're actually getting well compensated for the work you do as an artist and whatever agreement you had with the music company. So thank you guys for sticking with me and watching my video today. I can't wait to see you next time where we talk more about music business and everything. Bye guys.